Good morning, good afternoon, and good evening to everybody who's joining throughout the world. My name is Daniel London. I'm a partner in the Denton's global trade team based here in London. And it is my pleasure to moderate today's webinar examining the US Supreme Court's recent decision on the scope of the International Emergency Economic Powers Act, or the catchily titled IEEPA. Now, we're all aware of the consequences that have come about from Friday's ruling. And as has been pointed out to me by my fellow partners, I have the easy job today in terms of moderating. And thankfully, I'm joined today by a tremendous strength bench across the Denton's platform here to go through the niceties and the nuances of the consequences of the judgment. So if we can get the Facebook, I can introduce everybody. So, and now the Winter Olympics have finished, but on the US team, we have Mike Zolans, who's the chair of the US's regulatory and federal team, who is also a trade compliance lifer. Joined with there, we have Simon Steele, who is a partner and a seasoned litigator in all areas of constitutional and regulatory law. We also have Chris Feltzer, who is a partner in the Denton's Regulatory Public Policy and Government Affairs Group and is a trusted advisor on all things government affairs and regulatory. Moving slightly further afield, we have a partner from Denton's Canada, Sean Stevenson, who specializes in international trade and who we're very grateful here today is joining us from India as he's part of a trade delegation in that country. And then moving towards Europe, we are joined by Roger Matthews and Christian Lau, who are specialists in UK and European trade policy, regulatory issues, and compliance. So we have a packed agenda today, and working through, we will start by having an overview and a background in terms of the issue to date. We'll then have more of a deep dive on the US constitutional and regulatory issues following the fallout of the Supreme Court decision. We'll then pass over to Sean, who will walk through the Canada and the near abroad issues and the consequences of the decision, before then flipping over to Roger and Christian to talk about certainly the European angle, but also more broadly how the rest of the world might be reacting to the judgment. So, without further ado, I shall hand over to Mike, who will take us through and give us a background in terms of the matter to date. Over to you, Mike.
Great, thanks so much, Dan, and hello to everyone. What we thought we would do on the U.S. side, in order to make sure that we have enough time for questions at the end, and please feel free to post those in the chat, and we'll keep a running tab on those as we go, but is really to set a general understanding of all of the trade authorities that have been thrown about over the last several days and precisely over the last year or so. Because where we go from today is really dependent on these authorities as opposed to the IEEPA authorities that the administration initially used to try to impose the sweeping tariffs, first on, as folks will recall, fentanyl and cross-border drug trade, and then later on the reciprocal tariff side with respect to persistent trade deficit. So what do we have left after the IEEPA decision on Friday? We have this grouping of U.S. trade remedies that still remain, and for the most part, and we'll talk about this, for the most part, have a process and a history of their use. So Section 232, 201, and 301 are probably the most common and familiar trade remedy statutes that the U.S. Retains at this point in time. Understand that virtually all of these have a little bit of age to them, and were frequently used prior to the establishment of the World Trade Organization and in other multilateral systems up until the early to mid 90s. They've come back in vogue, as we say, what's old is new again, as this administration, as did the prior Trump administration and the Biden administration, used 232, 201, and 301 to, after investigation, and that's an important feature of all of this, after investigation and a determination regarding injury to U.S. industry, imposed a series of tariff measures. The IEEPA tariffs were imposed on the basis of largely a sanction statute, and the court determined that that statute did not authorize the use of tariffs as a remedy. The court did not expressly address these other statutes, but did imply pretty substantially that those remain valid and a material basis on which the administration can impose tariffs. So each of these, until we get to 338 and 122, involve an investigation by either the Commerce Department or the ITC, followed by imposition of tariffs on the basis of an injury determination. And these tariffs can be imposed either on a countrywide basis for countries that, in the determination of the US government, have engaged in unfair trade practices, or on a product category basis, as we've seen with things like wood products, steel and aluminum, and other types of raw materials and inputs. So these are pretty broad and sweeping statutes that remain unaffected by Friday's decision. The US administration has thus pivoted to other options that are available to them in the hopes of replacing the IEEPA tariffs with a different regime. What is left also unchanged by Friday's Supreme Court ruling is a commitment on the part of this administration to using tariffs as a mechanism for addressing economic inequities as perceived by the US administration, and for essentially trying to rebalance using these new authorities the trade between the US and really the global economy. So Section 338 and Section 122, as noted here, both allow for the imposition of tariffs. However, they require specific findings. And in the case of Section 122, which has been invoked as of Friday, they are time limited in terms of their scope. So where we stand in the context of the fallout from the determination, and we can sort of skip ahead to the next slide here, we stand in a circumstance where these tariffs, the IEEPA tariffs, have been fundamentally rejected by the court as a mechanism of imposing tariffs. However, on the timeline as we look at it today on the next slide, we now face a future in which these other authorities, particularly Section 122 and Section 338, may be used, and where the 232, 301, and 201 tariffs are very likely to remain a major policy priority and a major regulatory avenue for this administration. From here, I'd like to turn it over to my colleague Simon to talk a little bit about, on a more detailed basis, what the findings of the court were and where that leaves us with respect to some fairly important questions, some of which we can answer now and some of which remain open to some future speculation about things like refunds and downstream impacts and the validity and likely impact of the new tariffs that have been announced. But with that, we'll move ahead to the next slide onto a more of a deep dive, and I'll turn it over to Simon from there.
Thanks very much, Mike. I'm not sure I'll provide a deeper dive, but I'll try to focus a little bit more on the litigation and potential litigation side of things. So as Mike said, and as I guess everybody knows, on Friday, the Supreme Court ruled by a 6-3 vote that IEEPA does not authorize tariffs, period, under any circumstances. As Mike says, that has no bearing, really, in my view, on other tariff authorities, the established authorities that Mike talked about, and the less clearly defined authorities under 122 and 338 that also clearly at least address tariffs, whereas the problem with IEEPA, as found by the Supreme Court, is that it doesn't address tariffs at all. So again, it was a 6-3 vote, Republican and Democratic appointees in the majority, including 2 appointees of President Trump. And the rule of law is very clear. There's a whole bunch of stuff that the president can do when he declares a national emergency, including blocking imports, trade embargoes, all sorts of stuff, but just not tariffs. Because tariffs is part of a distinct constitutional power that belongs to Congress and not the president. Now, everyone agreed going into the case that tariffs is a congressional power. Everyone agreed that Congress can delegate the tariff power to the president. Everyone agreed that Congress has delegated the tariff power to the president under other statutes. The question was whether it had done so under IEEPA, bearing in mind in particular that it doesn't use the words tariff or duty, which Congress usually uses when delegating that power. Part of my job here is to save you reading 170 pages of judicial opinions. The bottom line of those opinions is they're not all that complex. They're just applying normal principles of statutory interpretation. On the one hand, regulate ... importation might be construed to cover tariffs. On the other hand, Congress didn't use the specific words it usually uses when it's talking about tariffs. Further, there's a general understanding by the Supreme Court as a matter of statutory interpretation that Congress doesn't create big powers by implication or by vague words. Most of the 170 pages were devoted to debates among the justices that will fill law review articles forever about the so-called major questions doctrine, which is essentially an argument about how strong that principle is. The courts presume that Congress hasn't declared major powers by implication. But those debates really do not affect tariff law in any significant way as I see them. It's important to be clear on what the court did and didn't decide. It clearly held that all the IEEPA tariffs are unlawful, and moreover, the administration never sought to defend them as being authorized by other tariff powers. So two different issues. One are those tariffs unlawful? Yes. Two, going forward, could the administration impose similar tariffs under the statutory authorities that Mike outlined? Also, yes. But it can't retroactively rely on those authorities to justify the tariffs that have been struck down. So Justice Kavanaugh suggested, as the president has now suggested, that he'll be able to replace the tariffs through his other authorities pretty substantially. Important to note a few things that the court did not address and why it didn't address them. The court didn't address refunds. Precisely no inference should be made from that, and it's not at all weird that it didn't. The Supreme Court functions on the basis of questions presented that are defined by the decisions below. The decisions by the lower courts in these cases didn't address refunds. They just left them to be addressed at a later stage of litigation. So, of course, the Supreme Court said nothing about refunds, other than the fact that Justice Kavanaugh joined the government in saying that the refund process could be a mess. The court didn't address trade agreements. Those weren't part of the issues presented to the court. And for the constitutional geeks among us, it didn't address more broadly how emergency powers might work in other non-tariff contexts, including, for example, arguments about whether the president had a lawful basis to declare a national emergency based on relatively small quantities of fentanyl coming from Canada. Can we flip to the next slide, please? Okay, so one of the looming questions is what happens in terms of refunds. There are various estimates out there, but it looks like there's about 175 billion at stake plus interest, representing about half the customer's revenue since the middle of last year. There's already 900 plus claims before the Court of International Trade, which will be addressing these claims. There's been conflicting statements. Public statements from the administration have suggested that the refund process will be very complex and hard fought. But in court, the administration made several statements as it was trying to get and successfully getting stays from the courts, saying that it will issue refunds to everyone who's similarly situated, and the CIT has indicated that it will hold the administration to that. There's now a pending motion to establish a generally applicable refund procedure. It's not entirely clear how the CIT will handle that. It's possible the government will argue that this should be done on some sort of a case-by-case basis. It's possible that this will be handled through an administrative procedure under the supervision of the courts or directly by the courts. Justice Kavanaugh indicated that refunds will be a mess. I'm somewhat skeptical about that. The data is there in CBP filings. There's precedent from the harbor maintenance fees cases back in 2001, 2002 for a pretty efficient process based on CBP data. And these are refunds. These are refunds to importers. They're not consequential damages. They're not going to compensate downstream owners or deal with whether this ends up with a windfall to importers. There may be some litigation about whether someone has a contractual or other basis to get a payment from an importer who got a refund, but have also passed on the tariff cost. But that's separate from the refund issue. Next slide, please. So Mike has already addressed a lot of this, so I'll be brief. There are alternative tariff authorities that the president is likely to use. There's the 122 authority, which has not been used in the past, but which is pretty clear. And was invoked by the president immediately after the decision. There's some exemptions. I've listed them here, including USMCA exemptions. I think there are a couple of, from a litigation standpoint, there are a couple of questions that may arise as to the 122 tariffs. First of all, while there's no particular procedure required, Congress has set a purpose for which they must be used to deal with large and serious U.S. balance of payments deficits. It is really the main one invoked by the administration. Query whether the courts can get into that. If and insofar as the courts can get into that, is there really a balance of payments deficit here? Several people, including Neil Katyal, who argued the case in the Supreme Court, have argued that Section 122 goes beyond congressional authority because while there are goods trades deficits, the U.S. does not have a balance of payments deficit. So that's a possible basis for litigation. The other possible issue is there's a strict 150-day limit, but the statute doesn't directly address, okay, well, what if the president declares that there's a new problem and issues a new executive order? Does the 150-day clock start again? He may or may not test that out. The other plausible theory is that he's using 122 as a sort of 150-day window before he gets in place all the other authorities, including 301 that Mike outlined for more sort of orthodox and less time-limited tariffs. Next page, please. Okay, Mike covered the other tariff authorities. The other point I'll just make, because it was raised by Justice Kavanaugh in his dissent, and has been raised by the administration, is what is this? What is this all? What are the implications of the decision for trade agreements? I think the common sense answer is pretty obvious here. If you've actually got an agreement and it's a binding deal, you've got an agreement, and who cares whether the tariffs that may have been the catalyst for that agreement have now gone away. On the other hand, a lot of the trade agreements that the administration has touted are more in the form of MOUs and understandings rather than binding agreements. And so, that is, I think, a significant part of why the president, for example, in his State of the Union address last night, has been very forceful in claiming that he'll be able to reestablish the tariff regime under the other powers that Mike outlined. That's it from me. Subject to questions.
Thank you very much, Mike and Simon. That was a fantastic deep dive into where we are on the US side. And I can already see a number of questions coming through on the Q&A. And just to reiterate that we have allocated some time at the end of the session to pick up questions that are coming through for the willing panelists to step forward. There are some pretty knotty ones in there, so I shall do my best to pick my victims carefully. Now, Sean, I'm conscious that you are in India right now, and we would love to bring you in to sort of outline sort of the Canadian position, also the UMCA, and anything else you might want to add, because we're very conscious that Canada in particular has been at the brunt of a lot of this, a lot of these tariffs over the last 12 months. And so please, floor is yours to sort of walk us through the Canadian perspective.
Thanks, Dan, and thanks, Mike and Simon, for setting the table. From a Canadian government position and a Mexican government as well, the decision was welcome news. Two governments that have long contested the tariffs that were imposed on them under IEEPA. From the USMCA perspective, it is also a generally speaking good news story. This generally reduces tariffs that were applied to both Canada and Mexico at a 35% and 25% respective rate to the 10% level that they are currently at. Could, of course, rise in the coming days, but as we speak, 10%. 10%, of course, for energy goods coming from Canada. That being said, the net rate that was generally applied to Canada and Mexico doesn't fundamentally shift. As Simon mentioned, there's the USMCA exemption from Section 122 tariffs, and that remains in place. As of September 2025, both Canada and Mexico saw a large spike in goods claimed to be USMCA compliant, and that ranged almost nodding up to 90% of goods moving into the United States. So for the large amount of goods moving from Canada and Mexico to the United States, the tariff rate remains zero, as long as those goods are properly claimed as USMCA qualifying goods. Actual duty rates from Canada ranged at roughly 3.1% of total goods moving to the United States. So while it's an overall good news story for the bulk of goods moving to the United States from both Canada and Mexico, it remains status quo. That being said, there are a couple other good news stories here. The Section 122 tariffs offer a few different elements that weren't in place before, and that includes, for example, duty drawback. Of course, if goods are moving into the United States and then being exported again, there's less of a concern there. Also, Chapter 98 goods, if people have considered customs classification and goods that might be moving through the United States on a temporary basis or therefore a limited period for a limited number of processes that are occurring there. Again, that is something that would not be applicable, and that has been very clear based on the orders that have come out of the United States. So, from a Canada-Mexico USMCA standpoint, generally speaking, it's a status quo, and if anything, it's a good news story. That being said, there are, of course, as Mike and Simon noted, various potentials that could come into play, whether it's additional tariffs being imposed under Section 122, moving from 10 to 15%, or 301 investigations that might target certain sectors or certain industries more heavily. Generally speaking, from the USMCA perspective, the decision is somewhat more complicating. And if we can maybe move on to the next slide. The USMCA review is currently taking place in all three countries. All three countries have undergone their public reviews and consultations. However, the USMCA review in itself is really supposed to kick off on July 1st. And really, there's a deadline that happens a month before July 1st by June 1st, where the parties are supposed to submit to the commission, the USMCA's commission, all of the recommendations they would like to see during the USMCA review. The lack of tariff authority in the United States right now is somewhat complicating for both Canada and Mexico, and likely the United States itself, because we don't know where the tariffs particularly stand at this point in time. If you were to take the 150 days out from the initial point of when they come into force, that brings us into roughly mid-July, so just after the USMCA review is supposed to kick off. So this is somewhat of a complicating factor for the overall North American bloc and the review there. And unclear if the 301 investigations that could come online would be completed by that time, although that might be a great impetus for those investigations to be speedily completed. So that's the sort of long and the short on the USMCA review. If there's the goal of providing clarity and certainty on the tariff situation within North America, the unclearness at this point in time of how the tariffs might evolve over the next 6 months is a complicating factor.
Brilliant. Thank you very much, Sean. Now, moving across the pond, we have Christian and Roger, who will take us through the reaction and intended responses on the UK EU side, both conscious that the EU and the UK introduced deals respectively. So sort of the consequences of that are interesting in terms of how they play out, picking up on some of the themes also that Sean has flagged there from a Canadian perspective. So Christian, I might invite you in at this point here to kick us off from the European angle.
Yeah, thank you, Dan. And what Roger and I have decided to do is to integrate, at least for purposes of today's discussion, the EU and UK considerations because there are some broad similarities. Just to recall, the IEEPA was the basis for the so-called reciprocal tariffs that the Trump administration had imposed on a range of countries, differentiating initially the tariff rates that would apply. And alongside the pending or completed Section 232 investigations, they were the motivation for both the UK and the EU to enter into tariff deals, agreements with the US on how the tariff amounts and potential product exceptions would be carried forward. Now, let me start by giving a brief overview of the two agreements that the UK and the EU respectively reached. Under the UK agreement, which dates from early May 2025 and was the first bilateral agreement that the United States concluded, both sides agreed that there would be a 10% supplemental US tariff on goods imported from the UK. The 10% would apply on top of all of the MFN tariffs that are in the US schedule and that apply in the ordinary course of business. There were a range of exceptions from that 10% supplemental duties. They mostly concern those products that are subject to Section 232 tariffs, as Mike already mentioned at the outset. So there's a couple of specific rules for cars and car parts. There's a quota where a 10% duty applies. It's 25%, well, in fact, 27.5% with the MFN tariff for out of quota imports. Aircraft were set at 0. Pharmaceuticals were subject to special rules, and steel and aluminum were reduced to 25% from the now applicable 50%. Those are still pretty substantial tariff levels that the UK accepted in, that the United States secured the UK's acceptance on in exchange for some enhanced market access for US goods in the UK. The EU's deal is quite similar, although in nuances different. The replacement tariff is a 15% all-in tariff, meaning that the 15% do not apply on top of the MFN tariffs. So they're inclusive of the applicable MFN tariff. In terms of the exceptions, again, there's a couple of nuances. For cars and car parts, there's a 15% tariff that applies, but there's no quantitative limit to it. Aircraft, there's a similar treatment, equally for pharmaceuticals. But for the EU, steel and aluminum were not included. The general public's reaction was, I think, by and large, negative or at least skeptical of those agreements because major concessions were made. And as we're thinking about what Friday's ruling might mean for those two agreements, we thought it's useful to keep in mind the objectives that the governments were pursuing in agreeing those two deals. Now, I think the first objective here, and just to recall the uncertainty in the middle of last year where tariff rates were changing quite frequently, the first objective was to secure certainty on the level of duties that would be payable. Now, with Friday's ruling, that objective is at least temporarily undermined because we're having a 10% duty applicable right now. And there are signs that it might increase to 15. It might also mean, certainly for the UK and for parts of the EU products, that higher duties will be applicable while the Section 122 tariffs are in force. The second objective was to secure exceptions for the Section 232 products, and that was achieved to some extent. Steel and aluminum are an exception, and Friday's ruling doesn't call into question that outcome. The third objective was to secure a deal that's better than a range of third countries. Read in particular China, India, but also others. The agreement had achieved that objective, but Friday's ruling puts us back to a situation where every country is subject to 10 or in future maybe 15%. So that objective has been undermined. there were questions around enhanced US, UK, EU coordination on approaching threats from China. That is subject to how the political dynamics will evolve, still something that those agreements could achieve. And last but not least, an important objective of the agreement has been to avoid, for both the UK and the EU, having to retaliate against the US. That's been an important objective principally for geopolitical reasons. Russia, the Ukraine support are key aspects to mention here. And those will remain important considerations going forward as the two governments think about the future of those deals, now that at least one of the fundamental bases for agreeing, the reciprocal tariffs, have been declared illegal and are in the process of being reconstructed. We don't quite know yet on what basis those Section 301 investigations might generate new legal bases. But these were kind of some important considerations we wanted to leave you with as Roger is thinking through next how both the UK and the EU might react. Over to you, Roger.
Yeah, thanks, Christian. If we could just flip to the next slide, please. So yeah, Christian's talked about where we have been from the EU and the UK side. I'm just looking to see how things look from here. So the first point is on the possibility of refunds. As Mike has said, obviously the mechanism for refunds and the availability of refunds is something that has a lot of uncertainty related to it. But I think the point for EU and UK businesses going forward there is certainly to assess whether or not they have incurred IEEPA tariffs, and to watch very closely, and obviously without putting a plug for our own business, to come to us or to keep a track from your legal advisors as to the certainty on that process as it evolves. And I think we've got some questions about that coming later. So as regards how the UK and the EU might react, I'm going to try and avoid too much crystal ball gazing, but I think it's safe to say that the level of that reaction may very much depend on whether the levels stay at the currently operative MFN plus 10%, which is not substantively broadly aligned with where the UK agreement currently is, and for the most part will not depart significantly from, or not make things massively worse for EU imports into the US, or whether it is, as announced but not yet in force, increased to 15%. And there has been quite a lot of indicative reaction, both in the UK and in the EU, as to how that might look if the 15% increase were to come into effect. And just to give a bit of a flavour of that, the indications from the UK side, there is an emphasis on how, in any event, the majority of the existing deal that Christian has just recalled would not change. So they're very much in part focusing on the bits that will stay the same, the bits that will apply. That's because there are exemptions covering categories that actually represent a large part of the UK's exports to the United States. But having said that, there is also a reference to the fact that, quote, no reciprocal action is off the table. Now, we've obviously seen a relatively perhaps a soft approach on tariffs from the UK so far. And there has been a lot of commentary about whether that soft approach was the right one. As Christian said, it was that these deals were not universally regarded as positive at the time. Whether we will see a more robust response if the 15% tariff is indeed implemented, that's one to watch. But the noise from the UK government so far is that no reciprocal action is off the table. So I think they're certainly at least keeping their powder dry for the possibility of a firmer response on that if that comes in. From the EU side, whilst the European Council had approved the deal, that has been paused by the European Parliament. And again, so we will have to watch that space, but there is at least some reservation as to whether that deal should go ahead and be completed if indeed a 15% tariff is affected. So I think it's safe to say that there is caution on both sides, and it's important to note that even though there have been in the course of the past year larger figures touted around for some countries, the increase from a 10% tariff to a 15% tariff is a very significant increase for some European businesses. So it's although it's only 5%, it is something that has economically a significant impact. And the other point I just wanted to recall is, as Christian said, the comparative position as against other countries is something that will certainly impact the position going forward. The position for Canada, for China, for India, for a number of other countries is probably markedly improved as against the position under the IEEPA tariffs. The position, at least at 15% for UK and EU, would not be improved. In fact, it would be worse than what they thought they had agreed. So things to watch for. Firstly, the UK and EU reaction if it does go up to 15%. Secondly, how will the UK and or the EU respond to any Section 301 investigations, the type that Mike and Simon described earlier? They have to focus, I understand, on identified unfair trade practices, and it's not clear what those will be. But the EU Digital Services Regulation certainly is one that has caught the attention of the UK government before, and that may be one, therefore, that might be cited as, I pick that as an example of one that may be cited as a basis for investigation in coming weeks. But I think that is very much a watch this space, both as regards what the US identifies as potentially unfair trade practice and what is the response to that. The next thing I think is just generally, what is the tone of the European response? Will we see an attempt to accommodate, to negotiate? That's been certainly from the UK side, Keir Starmer's approach so far. There was lots of commentary as to whether that has really worked. There was certainly a time when it was argued that it had worked, and maybe less so more recently. But whether we will see a firmer, more robust, perhaps even more coordinated response if the 15% increase goes ahead. And then the final point and things to watch for is the longer term. There is a lot of commentary in the UK and Europe as to whether the tone of the recent transatlantic relations is accelerating in a sense that Europe needs to be less economically close to the United States. Will this, again, probably more acutely if the tariffs goes up to 15%, will this build on that narrative as something that impacts the longer term perspective of the UK or Europe? And then finally, before leading it to questions, just a quick touch on what individual businesses might want to consider, apart from the possibility of refunds that I mentioned at the start. One point is, firstly, frankly, to brace for the possibility of the 10% increase going up to 15%, no matter what the response might be. It's clearly been announced. It's clearly a possibility that it might happen in practice. So to prepare for that. The second thing is to consider and to be ready to advocate for any possible sectoral arguments one might make as to the impacts of the tariffs at any applicable level on your sector. And that's something that will apply differently across different sectors, but it's important and valuable to have in mind the sorts of arguments that one might make, either to lobby one's own government to make them or directly. And then finally, to consider the relative impacts this has on decisions that companies have made about their supply and all their distribution changes. And that's not just in terms of shipments directly from the UK to the United States or from the EU to the United States, but also recalling that it might change the importance and the relevance of concerns that might have been worked through last year as to whether goods had, for example, Chinese origin or Indian origin, and the impact that those might make. So I think it's perhaps a timely moment for businesses that have international supply and distribution chains to have another look and see how those play out in the current tariff environment. So I'm going to stop there, hand back to Dan, and I think it might be time for questions.
Christian, Roger, thank you very much. Like a finely tuned vehicle subject to a 15% tariff, we have landed bang on time and ready for questions. And questions, unsurprisingly, have focused on what potential options, remedies, practical tips and tricks there might be out there to sort of place some conscious. Everything is fact specific, but Mike, I'm wondering whether you might be able to walk through what we're seeing out there in terms of possible options.
So I think the best way to answer that question, and we've gotten it from sort of a number of different quarters here in the Q&A, is to talk about again sort of where we are and where we might go. So as Simon noted, the administration made a series of arguments in respect of their imposition of the IEEPA tariffs, some of which suggested that they would be unlikely to argue about a refund protocol, others suggesting that they might reserve those rights, and at least one CIT opinion prior to the IEEPA decision that suggests that they would be inclined to rule in favor of refunds. So what does that mean in practice? Well, it means that there's both a legal litigation disputes related issue, and there's also an administrative procedure issue. So for those familiar with the customs universe, when you enter goods into the United States, at the time that goods are entered, there is a duty owed if one is required. You pay that duty either as the importer of record or through your customs broker, and those funds are remitted to the Customs and Border Patrol, or CBP. After that, there is a roughly 1 year period of time in which the entries are liquidated, not in the historical chemical sense or the organized crime sense, but in the customs sense. And that is a time period in which CBP reviews the entries have been made, reviews the duties have been paid, and reaches a final determination as to whether the math adds up. And during that period in time, the goods are essentially in the United States, duties have been paid, and everyone sort of like waits for that to be finalized. It occurs within a year. Sometimes it can happen more quickly for smaller value shipments. Sometimes for larger value or large denomination shipments, it takes a bit longer. But usually the average is around 350 days. So for companies that are serving as an importer of record and have entered goods and paid duties, but where the entries have not been liquidated, there is an administrative process available to essentially attempt to seek remediation and refund from customs before they reach final action. In a second sense, once entries have been liquidated, there is yet another administrative time period in which affected businesses can seek to appeal or protest the liquidated findings. And so that too remains an administrative remedy for entries that have been liquidated, but where the process for protest has not yet run. If you fall into the basket of neither of those two things applying, an entry that has been liquidated and the protest period is run, then to the extent that you would be in a position to seek remedy from the CIT, that would be a mechanism available. The many cases that have been filed to date have a wide range of theories that have been deployed. And indeed, just this week, new cases have been filed with yet additional theories. The original plaintiffs in the VAO case, the one that was the VOS case that was the basis for the IEEPA decision, filed an amended complaint just yesterday, in which they requested that the CIT establish a administrative remedy for issuing refunds that would not require everyone to proceed through the CIT. Other cases have been filed dating back to last year by large companies such as Costco in the US, Federal Express, which filed earlier this week, a wide range of apparel companies and others had another set of theories that essentially said they wanted to have the court just instruct for a refund and make it not a factual predicate, but just a matter of law to send it all back to CBP. So as Simon notes, it's not precisely a mess because there are established procedures for it, but the precise timing and ultimate remedy remain unclear at this stage. So, as the CIT evaluates all of these and reaches a determination as to how best to fashion a remedy, and how Customs and Border Patrol evaluates requests for a change during the liquidation process, or how the CBP responds to protests, in many respects, that is going to guide how the CIT responds. So I think that the best answer is to evaluate where in the trade life cycle your entries happen to be, and then take advice accordingly on the available remedies, which may be multiple.
Brilliant. Thanks, Mike. At this point, maybe we could bring in Chris Feltzer to walk through. There have been a few questions sort of broadly related to Section 122 and how the mechanics of that will work, whether it will be reissued, extended. So, Chris, maybe you can tackle that one head on.
Sure. Thank you, Dan, and thanks to all of my colleagues for their insights. As Sean mentioned, that 150-day period runs just about toward the end of June this summer. Bottom line up front, I would put it at a near zero chance that sufficient votes exist in Congress to extend those Section 122 tariffs. The tariffs are a political hot potato for congressional Republicans as we head toward the November elections. Democrats on Capitol Hill will seize on this Supreme Court decision to attempt to force uncomfortable votes for Republicans, whether focused on tariffs refunds or, in fact, to modify or undo any of the U.S. administration's current tariffs policy. For instance, some of you may have noticed that the House of Representatives voted to overturn the U.S. administration's Canada tariffs earlier this month. That was a symbolic rebuke. And so while we will see significant activity on Capitol Hill between now and November, we should view that more so as symbolic because it will not have a material impact on the administration's policy other than the fact that the votes do not exist to extend these 122 tariffs. There just simply is not a veto-proof majority in either chamber of Congress, such that the activity will be representative of political setbacks, perhaps, but really not have a material impact on the policy. The last point that I will make, we should view at this stage the Section 122 tariffs as a bridge strategy by the U.S. administration. To the points that Mike and Simon have shared, we can expect to see significant activity emanating from the U.S. administration with respect to additional Section 232 and Section 301 tariffs. So those are coming. Forgive the pessimistic view, but it's not mine. Many economists, many close trade observers have said that at this point in time next year, we may all be looking back fondly on the IEEPA tariffs based on the activity that is expected under Section 301 and Section 232.
Chris, that's brilliant. And Simon, I might come to you for one last question here. And we've had an interesting question around the dissenting judgments. And I think for the trade nerds amongst us, they did make quite interesting reading. So I was wondering, are there any nuggets within there that you might see reappearing either through the administration's future tack or anything else you want to flag before we close today?
As I said, it's a largely academic debate about the major questions doctrine. This notion that Congress does not confer broad novel powers by implication. In general, historically, the more conservative Republican-appointed justices have been fans of the MQD. The Democratic justices have not been fans of the MQD. That was particularly true during the Biden administration when those issues focused heavily on major environmental regulations, climate change, et cetera, et cetera. But again, it is closely tied up with just the common sense principle that if Congress has something important to say, presumably it's going to say it clearly. So we're dealing with nuances and shades of gray here. I really, while we've flagged possible areas for litigation regarding the other tariff authorities, like, for example, whether Section 122 is truly, the executive order is truly addressed to a balance of payments problem, I really don't think that the debate in the court, it certainly doesn't directly affect, and I don't think it creates much basis for tea leaf reading as to how future litigation regarding tariffs might go.
Thank you, Simon. And I reckon we do have time for one last small question. So, Mike, if you want to pick up the questions we've had around tariff stacking, that would be great.
Yeah, this is a question we're getting quite a bit right now, and it largely depends on which trade agreement you're talking about and how the administration has responded. So, as Sean noted, and as Roger and Christian discussed, the existence of free trade agreements as between the US and particular markets have been entered into over the last year, in the case of the USMCA, even much longer. And in some of those instances, the 122 executive order exempted those FTAs from the scope of the new 122 surcharge. And I think it's important to note that it is denominated a surcharge, which, while not having any meaningful distinction in the world of ad valorem duties, which they all are, the fact that they're denominating it in this context as a surcharge means that, in fact, unless exempted, it does stack. So the practical consequence of a lot of this tariff discussion is really that, depending on where you sit in the world and what the reduction was that was negotiated between your home country and the US government, you may be in a better position or even a potentially even or worse position depending on where you sit. So it's really important to carefully evaluate the scope of the executive order. Again, this is a space that continues to change and remain dynamic. The percentages may change, the scope of exemptions may change as the administration kind of tailors its policy in response to industry requests, in response to other countries' requests. But in the short term, unless exempted, the additional 122 tariff of 10%, which as it exists today is 10%, is going to be stacked on top of additional duties. The exemptions to that so far are DR-CAFTA, USMCA, and the the 301 and 232 duties. So if you're subjected to 301 or 232 tariffs, you don't have stacking. Same with DR-CAFTA and USMCA. But for everyone else, the FTA does not provide an immediate point of relief from the additional surcharge.
Mike, that's perfect. And with a minute to spare, I can bring this webinar to a close. A huge thank you to my colleagues, wherever you all are in the world, and a big thank you to everyone for joining today. Hopefully you found this useful. We wanted to get something out quick and fresh following Friday's judgment, and we're delighted that we were able to do that. So please follow us on LinkedIn, look out for our alerts and future webinars that we're doing, both in relation to this issue, but on all other issues regarding international trade. So with that, thank you very much and have a wonderful rest of the week. Take care.